I can't change it. I have to give you 1 week if you're in custody, 2 weeks if you're not, and that's all I can do. I can't change it.
Okay, so June 25th.
Right. I'm not saying it can't be changed. I don't have the authority to change it. No, he was just, I knew the reason he was ignoring his favorite judge was because he was busy out there, but it still hurts. Were you gathering a little wool?
You know, when I was, multitasking on my other case, I'm ready.
All right, come on up.
We're ready on both cases, Your Honor.
All right. I'm sorry, what's the other one? I don't think I have that file yet. Let me grab it. All right, and that is also a waiver, counsel?
On that was.
All right, so let's do Parham. Officially put your appearance on.
Your Honor. Agent 4364561 of India's Detroit on behalf of Ms.
All right, Mr. Parham, you're going to waive an exam on both these files? Good morning. You understand your rights and the options those rights give you? You understand the purpose for the exam?
Yes.
Sir, do you understand that if you waive the exam, that means your next court date's going to be at the circuit court level, not at the district court where we're all at today? And understanding all of that, you're waiving and you're doing so freely and voluntarily, is that correct? Counsel, are you satisfied with the waiver?
Yes.
So am I. AOI is going to be 2 weeks down the road, 25th. That's going to be at 9 a.m. I will continue your bond, Mr. Parham, and wish you luck.
Sorry, in the CJC.
I can't change it. I have to give you 1 week if you're in custody, 2 weeks if you're not, and that's all I can do. I can't change it.
Okay, so June 25th.
Right. I'm not saying it can't be changed. I don't have the authority to change it.
Thank you.
You're welcome. I wish you luck downtown, Mr. Parham, and I need signatures from both of you if I can find the paperwork.
Permission to approach.
Yeah. Your officer will get it.
Oh,
Save your steps. Gives me time to finish writing. Catch that. Yeah, I got another one coming.
Oh, well, it's 4 months serious. You need.
All right, anybody else got something ready?
Yeah.
Joe. That's the old uniform? Who is it?
SWAT. Hey, I would guess Western Wayne. I don't know. I didn't look at that.
Green? What case had it? No?
So it's probably all right. He just shook his hand.
Mr. Haley, you got anything ready?
We got one case left.
Okay.
We're trying to resolve.
That's all right. I was gonna take a quickie before I start the exam. All right, your appearances on Stickler, please.
counsel.
Appearances?
Morning, Your Honor, I'm here requesting to try to bring 120
Granted, spell your last name.
AMPEONSAH.
And say it again.
AMPEONSAH.
And Panza?
Good afternoon, Your Honor. MG Moore, Precinct 4561 of NDS Detroit, on behalf of Mr. Stickler. Sir, please state your name for the record.
Stephen Paul Stickler.
Thank you. Have a seat, people.
G Lefty, a supervisor, 8840.
All right, let's get started.
Director would like to call our first witness, Waiver.
Baker.
Waiver.
Ba- Ms. Baber, come on front. Right over here. Watch your step on this incline ramp right here. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? Have a seat in that chair right there. Baber. When you're ready, counsel. What's the name? Thank you.
How do you know the defendant?
Leslie.
Yeah. Nope.
If you saw him today, would you be able to recognize?
Yes.
Sure. Let the record reflect the witness has identified the defendant.
Noted.
Were you at or around 51077 Freedom Way, Township, Michigan, on July 9th, 2024?
Yes.
Is that in Wayne County?
Yes.
Can you tell me what happened?
Mr. Stickler was over there with my daughter. He wanted to start an argument with me.
What happened next?
I told him that he was gonna start things that I hope that he needs to leave because I didn't want to leave my daughter.
And then what happened?
He still proceeded to argue with me, so my mother was playing a game on my phone. And I went to go grab my phone from my daughter, so I could call the Bureau Police Department to have them to try to get him to leave my home. And then he came in the kitchen and grabbed my phone from my hands, slung it over on the kitchen counter,
And then what happened?
and then I'm sorry, I just. After he saw my phone on the counter, he, I'm sorry, I'm getting very anxious. He shoved me up against the kitchen sink aggressively and was up in my face, making threats to me. And I reminded him that our daughter. Objection as to the generalization in regards to the making threats.
What was said specifically? What was said?
What's that? I'm sorry.
What were the words that were used?
I don't remember this. Okay, and Brian Conti and I contacted the police.
Go ahead.
What happened?
After that, he went to go walk away. I went to go grab my phone again off the kitchen counter where he had slung it to try to contact the police again. When I did that, he walked back in the kitchen again, took my phone from me and slammed it as hard as he could on my kitchen counter, breaking my phone and smashing it.
What happened?
After that, when he went to go to walk off again, I grabbed my daughter by her hand. I went out my back door because I was gonna go to a neighbor for help since I didn't have a phone anymore. And when I did that, Mr. Stickler got his dog, he got his car, and he left.
And then at any time did you get him for drive?
No, absolutely not.
At any time did you get him consent to show you?
Absolutely not.
Do you know Mr. Stickler?
Yes,
Is Mr. Stickler invited that you identified earlier?
yes.
Thank you. No further questions.
Ms. Moore, your witness.
Definitely. Yeah. How long have we known this? I don't know if it's since I was. We both grew up. It had been a number of years. 20 plus years.
What is the age of the child that the two of them?
She'll be 6 tomorrow, man.
On July 9th, 2024, were the two of you living together?
No.
And how many different addresses have you and Mr. Stigler lived in together over the past 20 years that you've known?
3.
And is it true that at least 2 of those addresses, you went to the police department and made statements to the police and then texted Mr. Stigler, quote,
Objection, relevance?
What's your relevance?
it goes to the veracity of her testimony today. Because she, in her text messaging, after her complaints to police, she calls the police dumbass cops, quote unquote,
Okay.
because they believed her. And that was gonna be the basis of my questioning, is to demonstrate that she's made these knowingly false statements with the intent to knowingly trick, manipulate, deceive law enforcement.
Sure, I'll allow it.
No, that's not true.
And did you not send a text message to Mr. Stigler stating the dumbass cop who showed up believed everything I said?
When, counsel, when? For this current incident?
Let me check my.
Sure.
Oh, we don't have a date.
Well, she's already said she didn't do that at prior addresses, so let's stick to this incident, the July 24 incident.
You're aware that Mr. Stigler has a new girlfriend?
No.
Really, you're not advancing this action just because you're mad at him moving on?
No, listen, I don't contact order. I don't know what this stuff is.
Really? So you know that there's a no contact order in place?
Yes, I do know there's no contact order in place.
Is there a reason why on May 14th, 2025, you initiated contact with my client by sending him a message on his phone?
No.
I didn't know you were here today.
Not more often.
He's getting better. I didn't rattle him. That would have rattled him 6 months ago.
Sometimes she was that when she asked for last under officer. She was in.
Ma'am, did you not send him a text message May 14th that says, if you don't come see me or at least call me, I will have you violated, Stephen? I'll just tell them you were here and have one of my kids back me up
Absolutely not.
on May 22nd.
Absolutely not.
Did you send a message to him that said, I see you got a new whore? So who is Cassie? You think you're so slick? You were hitting like all her pictures. Oh, no, you were hitting like on all her pictures. Talking to her on Messenger, giving away my daughter's toys to her. Didn't you just go ghost from Facebook today? You think I don't know you? That I don't know you probably spent the day with her and her hillbilly ass looking kids? I keep telling you that you're gonna get one of these BITCHs hurt, Stephen. I was going to not go to court, but now instead, I think I'll message Cassie a few of your pics, just so she knows what a BITCH you are. Let her know how you abuse me and Mila on a regular basis. I'm putting your bitch ass in prison this time, and there's nothing your ass can do about it. LOL. Cassie looks like more of a dyke than your cousin Dawn, so she might like you on your pink outfit. SMH. Did you not tell her that?
Absolutely not. And I have had to file police reports from the state that were creating fake Facebook accounts in my daughter's name and emails, and I have made police reports about that, knowing not, I have not messaged or talked to Mr. Fairweather.
Is this your voice?
Oh, I gotta hear that first, sorry, Jim. Sorry, Jim. I need to hear that first. If not, we can approach first, but sure,
What, you want to approach it here?
you okay with that?
Oh, I don't care. Let's go this way. Doesn't say. This one.
All right, now, play one of the messages. Was that song new to you?
No, it was not. Like I said, I haven't known.
I'm sorry, I have a question here, other than that. My question to you this time is there any other woman who, I'm sorry, is there any other person you know to be Mila's dad?
No, but that, I had not talked to Mr. Fairweather.
And do you know of anyone else that would leave a message and say, Dr. Waiver, he was dead? Is there anyone else you know who would say that?
No.
Okay, thank you very much. Sir. And the daughter, the two of you have in common, her name is Venus?
Yes.
No further questions.
Anything else from the people?
No, Judge.
You can step down. Watch your step on the ramp. Any other witnesses from the people?
People else.
Any defense witnesses, Ms. Moore?
No.
I am ready for argument.
Yes, Your Honor. You've heard testimony today, from one witness, Tiffany Berger, that at 5107 Freedom Way in Van Buren Township in the Wayne County, Berger, during the altercation, there was an argument in front of their daughter, during which place, in particular, without consent of Ms. Barber, assaulted and or assault battered Ms. Barber by pushing him, thus meeting the elements of both domestic violence, that there was an assault and or assault and battery, and that Ms. Barber and Mr. Stickler had a child in common. The two elements people need to prove that have been proven by the law.
Ms. Moore?
Your Honor, this argues that the defense argues against Bindover, that the people have failed to meet their burden. There is serious question as to the veracity of Ms. Baker's testimony today, particularly when measured against the text messages and video recordings that had been left on my client's phone. It's unreasonable for any person to believe that a different person would be the father of a child at the time. So what other person but the mother would leave the message that the complaint witness left on my client's phone. It's clear from today's case that Ms. Baker's impetus for advancing this case is not the pursuit of justice. More so, it is to give retribution for unrequited life. My client is walking away, she's not willing to let go. And even in the midst of no contact order, still initiating contact and yearns for him to contact her with the threat of violating him, causing him to lose his friend, just so that she can have her. So where are the against Bindover?
Brief rebuttal. Your Honor, this time the motion to bind over, counsel stated, is not in evidence and
None of it. None of it was in evidence.
nothing in evidence and no authenticity reported to be. Therefore, we report, matter of to be on this one.
The only way I could do my job and not bind over is if I found Ms. Baber's testimony to be totally incredulous, which I did not. So the AOI will be June 25th at 9 a.m. Bond will be continued, And I wish you luck downtown.
Fingerprint.
Oh, and counsel, we need him fingerprinted. This was Van Buren. Can you appear at Van Buren Township PD today to get your prints taken? Could you just answer my question?
So when I leave here today,
Answer the question.
I can go to Van Buren.
Awesome. Okay, thank you. You too, come on.
It's Friday. Were there any statements made by the defendant to you?
Prior to this testing,
What?
he advised the guy out this people, their level of intoxication, one being the lowest, and even the highest. He advised the lowest.
Were there any other statements made to you by the defendant?
They were helpful, if they're
Do you recall if there were? So if you don't recall, definitely can click it. Would that help refresh your recollection? Yeah, please refer to your report. Has your memory been refreshed?
Yes, it is. Prior to the testing, I needed to take 4 milligrams of Suboxone,
Say, advise what?
take 4 milligrams of Suboxone.
Thank you.
Thank you. And officer, Your Honor, I'd like to introduce into. Your Honor, I'd like to introduce into evidence pursuant to MCL 76611. A copy of the MSP lab reports. There's 3 of them. Will reflect different drugs that were detected. And this is being introduced. For example purposes.
No objection, for example.
Thank you for the stip. Proceed.
After you had conducted an arrest, what happened next?
So every time I was in the pair, I stayed driving around state for region and it's difficult. Well, the evidence that I said, I read it, ran it in the bag, just. He said, see if you will consent to a blood whatever you were test. I if you would consent to a blood test and you do
And how did he consent?
verbally. With dedicated with your relationship.
Okay.
Thank you.
After the defendant had consented, what did you do?
Transport to go on Taylor or later roast.
Excuse me. Thank you. No. Oh, I take back my thank you. Go ahead, Mr. Mohammed.
After the defendant had consented, what did you do?
Transport to go on Taylor or later.
And what happened?
So when you get to the hospital, full lines will open the box, it's sealed. They open it, they complete the 2 vials, they draw 2 vials, they complete the forms, and then they seal it back up. That's when I take it back to the station and I put it in the hospital.
Was that MSP blood kit?
Yes,
And did you observe the defendant's blood being drawn?
yes,
And after, did you recover those, that item after the blood draw was conducted?
yes, I mean, I observed the little bottles. They handle all the blood, so they put it in the back and
And then you took possession of them.
I said, possession of back to the station and was placed in the mail.
At the time that you had started speaking to the defendant, was he ever provided you with his driver's license?
Should we not recall?
Do you ever perform a research into the defendant?
Certain person?
A leading search?
Yes,
You did?
yes.
Did you discover anything?
I do not recall. Can I refresh my report?
Would that help refresh your recollection? Has your memory been refreshed?
No. Yeah.
No further questions, this witness.
Mr. Martin.
Good afternoon, Officer Fox, right? So, a question for you. I want to start. When you say you first observed Ms. there, so you say that you were on your way to this address where you received a police call.
Yes, sir.
To assist another investigation,
Yes.
another department. And that while you're on your way, you said you observed a black sedan that was speeding. And that black sedan stopped at the address that you were going to.
Yeah.
And that's the car that you say Mr. Lazaire was driving.
Yes.
So I just want to check that that's your testimony when compared to your report. So I have, may I approach it?
Sure.
So Officer Fox, with this title here saying RP Fox, this would look like your incident report. Do you agree that right here it reads Officer Fox was standing by at Gorman and Grant when Brandon Lazaire pulled up in a Chrysler 200?
That was not my report.
Oh,
That started on your report.
Oh, that's Sergeant Otter's report.
Like, it starts here and then goes.
Oh, on the page 16. So
This is one.
this is your report saying that Officer Fox observed black Chrysler 300 going over the posted speed limit and pull over in front of you, and then you made contact with the driver. So that's your
That's
report.
fine.
Understood. But now you didn't use any radar on that car, did you?
No.
And so you also don't have a number, you're just thinking that it was exceeding 30 miles per hour.
I mean, with my, I've been doing this long enough, 5 years, I worked a lot of traffic details, I can usually tell when a vehicle's traveling over the posted 25 miles speed limit or whatever.
So just based on looking at the car. You weren't pacing the car or anything? So. And you didn't observe any other traffic violations, any other traffic infractions?
Just been traveling above the posted speed limit,
Okay,
I'm sorry, say it again.
just traveling above the posted speed.
Thank you.
and like you said, you don't recall whether there was infraction related to a license not being valid.
I don't recall.
So I told you actually that his license was found to be valid at the time, you would not dispute that.
That's what it says in our legislation.
And so. And what you described as speeding, you didn't describe that as swerving.
I mean, just what it just looked like he was traveling above the posted speed limit,
So he was not.
and I recall.
So once he gets out of the car, he's immediately talking to you in your car, right?
I think I'm having originally in the. Oh, I had to step out.
Okay, so as soon as he's stepping out of the car, he's knowing he's having police contact, right? And safe to say that he came off to you as nervous.
Yeah, he'd be nervous, he's sweating, and then he's also doing abnormal things with licking lips and things like that.
Okay, but yeah, nervous, you agree. But he was having a coherent conversation with you and your officer, right? It's not like you couldn't understand what he was saying.
Sure.
And he told you that you used Suboxone that day, right?
4 hours.
4 milligrams of Suboxone. He said that was earlier in the day, right?
He just, yeah, he took it. Then I asked him if he was under the influence, did he take anything? He said 4 milligrams.
But But you asked him if he'd taken that, you kind of had a compound answer there. So you asked him if he'd taken anything, and he said 4 milligrams of Suboxone, right?
Correct.
But then you asked him if he was under the influence, right? Didn't you ask him to rate his level of intoxication on a scale of 10?
Yeah, 1 of 10.
1 of 10, and his response was 0, is that right?
Yes.
Indicating that his report to you was that he's not intoxicated or impaired at all. And to your knowledge, Suboxone, that can be a prescription medication, right? It's not an inherently illegal drug.
He typically for sure.
And to your knowledge, taking Suboxone does not necessarily make someone too impaired to try.
That I don't.
You don't,
It's a schedule for you, it's on that.
okay. Just testimony, you don't know the relation between Suboxone and impairment.
Right. I don't know if it makes you better or not.
Okay. And you had no indications that Mr. Lazare had used alcohol?
No.
Right, so when you were alluding earlier to the field sobriety test you were performing being indicative of a certain blood alcohol content, that's not at all in relation to suspicion of Mr. Lazare having consumed alcohol.
Correct, that's just, I mean, I went through the Waiver, which is advanced drug sanitary drug. So that's just the way it's worded through the National Highway Traffic Safety, is that these tests are testing the 0.08 or above, or tested by, any non-alcoholics.
Sure. But as you saw the lab report, you agreed that the result was no alcohol found in blood. There was no odor of intoxicants or anything.
Correct.
So. You did these field sobriety tests and you stated that you failed some, but you didn't fail all of them, right?
The standardized test that goes.
The test that you administered in terms of reciting the alphabet, you could do that.
Yeah, that's not standardized, something that when I gave you.
I believe you also reported that he had equal pupil dilation tracking. Yes. So I also just want to ask about your prior knowledge of Mr. Lazare. You had never met him, right?
No, sir.
Okay, so you have no idea, or you had no idea at the time, kind of his normal personality or mannerisms, his normal speech patterns.
No.
Didn't know whether or not he had some sort of nervous tick that, prompted his body to move in maybe abnormal ways. Didn't know.
Never thought that would.
And I know you asked him, if he had used glasses or contacts, but you didn't ask him if he had mental health diagnoses, did you?
No, this is something else.
Okay, you didn't ask if he had any particular disabilities beyond like the vision impairment that I was just talking about. And you didn't ask him if he's on any prescription medications,
You just hesitated.
and he answered Suboxone. And you never witnessed Mr. Lazare consuming any controlled substances, correct?
No.
You never found any controlled substances on his person, correct? Was the car impounded?
Released on scene.
It was released on the scene. You didn't search the car.
I did not started doing anything.
Okay, so to your knowledge, no drugs of any kind were ever recovered. Now, said you put him under arrest after the field sobriety test for operating under the influence, right? And it's after that point, you're asking him consent to a blood draw, right?
Yes.
And your testimony is that he gave you verbal consent.
And I put a time in there as well.
So you thought he was sober enough to consent to a blood draw?
Yes.
Okay. And so no warrant was ever sought.
No, if he did able to consent to the blood draw, I read it back with the ambulance system, he's able to verbally consent to the point where he's not involved traffic crash or something where he can't speak, he can't stand. Obviously, he could. I read that he's to the blood draw. I asked blood draw. I asked blood there. He's no alcohol. He said he was doing the experience.
So your testimony is that unless someone is too drunk to speak or stand, they can consent to a blood draw
So while in the traffic crash, the possibility.
or in a traffic crash with a head. So apart from those circumstances, your practice is to seek verbal consent,
Yes.
and that's what you did in this case.
Yes.
Now, turning back to those lab results, we already covered that one of them indicated no alcohol. Another one indicated amphetamine. Now, based on your training experience, or due to past knowledge, do you know if amphetamine is an ingredient in prescription drugs?
He was breathing out.
In Adderall, yes. And I believe there was a result for buprenorphine. To your knowledge, is buprenorphine an ingredient in prescription drugs?
Never heard of that.
Okay. And the last one listed is mirtazapine. Do you know if that's an ingredient in prescription drugs?
No.
Okay, you don't know. That's fine. But the ones that you don't know about buprenorphine and mirtazapine, you don't know these either to be street drugs or controlled substances that are commonly used for safe to say.
I mean, they're not street drugs, and can't tell you if they're controlled substances.
Okay. And you don't know for any of these substances, whether it's amphetamine, buprenorphine, mirtazapine, if there's some sort of legal limit of the amount that can be in the blood that impairs driving. You don't know.
Then
Okay. All right, I have anything further. Thank you.
Mr. Mohammed.
At any point where was your lights or sirens initiated prior to making contact with the defendant?
No.
Okay, no further questions. This witness.
Nothing. You can step down. Can we send Officer Fox back to Warren?
Yeah.
All right, watch your step on my ramp, officer. Drive safely. Any further witnesses from the people?
Just one, Your Honor, it's gonna be Officer Kosecki, and just as an offer of proof, he's the officer in charge of the case, and we're going to case being charged as an OWL third. I'd just like to make better record as investigation. Officer Kosecki.
He's, because she's reruns. Corporal, raise your right hand. Swear or affirm to tell the truth, tell the truth, whole truth, nothing but the truth today.
I do.
Thank you. Settle in. When you're ready, Mr. Mohammed.
Thank you. Good afternoon, officer. Can you please state your full name for the record?
Corporal Christopher Cosasti,
Can you please spell it?
KOSOSKI.
First name.
Christopher, CHRISTOPHER.
Officer Sassi, how are you associated with this case?
OIC prepared the warrant packet, submitted it to the prosecutor.
Okay, and as part of your duties as the OIC, what documents did you submit to the prosecutor's office?
The police report, OIC report, which is the investigative report, any type of lien work, other packages too that might be required. I'd have to pull out the package.
Okay. Besides the facts, did you look into the defendant that you had submitted the case on?
Yes.
Did you discover anything?
A history,
Yes.
like criminal history.
Yes, what did you discover pursuant to your investigation?
For operating while intoxicated, this would be a third offense.
I'm gonna object at this point. I object to criminal history being admitted in this way as a hearsay statement of an officer repeating statements that he must be reading either through lien or to a register of actions. The typical procedure here is for the prosecution to come prepared with a certified copy that would be admissible. At this point, I don't believe that this type of hearsay is admissible, and I don't believe that the prosecutor is in possession of any sort of admissible documents to.
Your Honor, I don't have to turn over any certified records. There's no such rule that I'm aware of where I have to go get, we're not gonna drive around the country and go to each district court asking them for a copy of their case that where the defendant pled guilty. This is an officer testifying personal knowledge of what he learned pursuant to his investigation. And I was gonna ask him follow-up questions. What did you submit this case as? Why did you submit this as that? So, and also, the elements of this case is that the defendant was operating while under the influence. The third offense notice, that's a sentence enhancer, so I disagree with defense. I believe Officer can testify to what he learned with his investigation. I can change the way I'm asking the question. I can ask him, what did he submit this for and why he did that and what that was based on. I think that's a little more appropriate.
Any response?
Your Honor, there must be a standard procedure here, and the standard procedure that I'm most familiar with comes from, felon in possession of a firearm case. We don't just call in the OIC to say this person has a felony record. We have to show up with that certified record. Now,
Different statute. Are you aware of any statute or court rule that requires a certified record at this stage in the proceeding?
there's not one, nor is there a hearsay exception.
Then we'll allow it. Please appeal me. Let me know I'm wrong. It's a probable cause hearing.
And just to follow up, officer, what did you submit this case to the prosecutor's office as?
Operating while intoxicated, third offense.
And why did you submit it as a third offense?
Because the criminal history showed that previous conviction.
I'm sorry, I was.
Make your record. That's all right.
The last ruling, were you ruling that you were allowing this testimony?
Yes. Yes, because it's a probable cause hearing, and in certain circumstances, hearsay is okay to establish probable cause. I'm not aware of anything specifically says you can't do it for the prior drunk driving conviction, so we'll make new law if we have to.
And I'm not sure, what was the legal objection?
I'm withdrawing my most recent objection. My prior one was based on hearsay.
And Judge, just for the record, I believe that it would be an effect on the listener officer testifying to why he's submitting it as an OWA. But I know Your Honor, you've already made it.
That's if I made my ruling, but if you guys want to make a record, make a record.
Officer, so just to clarify, why did you submit it as OWA?
Based off the history of convictions.
And what were those convictions related to?
Operating while intoxicated in the past.
And how many?
At least recall minimum 2. There could be more, but at least a minimum of 2. That's why it makes it third offense.
Understood, no further question.
Any follow-up, Mr. Martin?
Just very quickly, Corporal Kosowski, your understanding from this case is that Mr. Lazare was released after his blood draw was possible.
If I recall correctly in the report, I believe it did say that from the arresting officer.
Right, so probable cause wasn't established until these lab results came back, is that right?
Or I would say negative on that part. I'm trying to recall if it's, but I go forward with that for confirmation, 100% confirmation when the lab results come back. Yes, it's exactly, we know what's in the blood content.
Okay, but you wouldn't dispute that a decision was made after the blood draw to not take Mr. Lazare into custody at that time. You don't dispute him.
So repeat that, say that one more time.
Mr. Lazare was not taken into custody for an OWI after his blood was taken and before you got the result. You don't dispute that.
Judge, I'm not objecting. It sounds like a compound question. I was just asking for, I'll rephrase.
Rephrase, yeah.
I'm sorry, I was just.
Yeah, that's okay, but. So. We agree that Mr. Lazare was taken to the hospital, had a blood draw. And was released.
Up until, he wasn't in police custody up until the time of the, after the blood draw, if that's what you're getting to.
Yes, that's my question.
Yeah, after he's getting to, from what I recall, one of the initial officers report said that he was released after,
He was released after that.
from what I can recall.
Okay, all right, nothing further. Thank you.
Go for the
You
question.
step down. Watch your step.
Go for the witness.
Any witnesses from the defense?
None.
Ready for argument?
Both bind over and reserve any rebuttal at this time.
Your Honor, I am objecting to bind over in this case. I have a few issues with this case. Number one, I don't believe that these labs that have been submitted into evidence for this exam are sufficient to prove intoxication. For one, you got one of them saying no alcohol. So that we can't rest this on alcohol intoxication. And you have one of them listing amphetamine, which we have testimony, correct testimony from Officer Fox, that amphetamine is.
Do you ever see an individual in custody?
Yes, after jail.
And do you know, was that same individual associated with the reason you were at that location?
Yes,
How do you know that?
I can visually see the arrestees in the jails, just from.
How do you know that that was the individual that was associated with the vehicle that you were searching?
Through lien information?
Okay, so you never observed the individual that you've seen at the jail at the location of the crime?
He was in the rear of the officer's vehicle on scene still. I just never had personal contact with him. I can say that I discovered in the vehicle rental agreement paperwork for that vehicle with the arrestee's name on it.
And what was that name?
Ego Sarnios.
Was there a photo associated with that vehicle?
No.
Your Honor, I can't move forward. I don't believe there's anyone here. There's no one here that can do in-court identification. I mean, we have. What we have is paperwork, I think that is issues mentioned, but. Say that this is the person that was in that vehicle. We don't have that. The officer was subpoenaed to be here and he's still to appear. So based on that, I can't move forward at this time.
Dr. Glenn, Commissioner Rule for dismissal.
Granted. Appreciate that, Mr. Muhammad. You're all set. Is he no longer with the department?
Troy.
Went to Troy. Everybody's moving around.
You know, how to spell his name correctly?
Just like the baskets.
That's nasty.
You guys don't know Longaberger baskets. Are you kidding?
LONGENEAR.
Oh, that's what he said. What, how do you spell the first name? The normal J O R D A N? Yes.
You got any more of these out here?
I probably do in my office.
You know Longaberger baskets?
Yeah.
We'll try it. Okay, so are we done?
Yeah.
Thanks, George.
You're welcome. Be safe. Man, we got some interesting ones today.
Yeah.
But none of you felt that Mohammed
You know-
was working on.
No, he was just, I knew the reason he was ignoring his favorite judge was because he was busy out there, but it still hurts.
I was definitely not. I was, it's really busy.
Man, your department's let you down today.
What's that?
Your department's let you down today.
In this heated DUI hearing, the defense argues the lab results only show prescription substances like amphetamines found in ADHD medication, and says the methamphetamine listed was detected but not quantified, meaning no clear proof of illegal use or impairment. They also challenge the blood draw, claiming it was taken without a warrant and without proper consent, calling it a Fourth Amendment issue. The prosecutor argues meth was detected and officers observed signs of intoxication, see which meets probable cause. The judge calls it a weak case, but rules there's just enough probable cause to move it forward to trial. Do you think trace drug results alone should be enough to justify DUI charges? Like, share, and subscribe for more real courtroom breakdowns.